Did you know that some performance evaluation systems can legally discriminate against you without ever mentioning your gender, disability, age, or race? Well, in this video, we're breaking down how performance evaluations can be weaponized to push employees out and subtly discriminate against employees while staying within the legal gray area. Plus, we'll reveal key signs of bias in your evaluation and what you can do to protect yourself. Hi, I'm Harlow Reed, creator of the HR Insider. Today, we're talking about a policy on performance reviews at GE that resulted in the discrimination of some of its employees. On this channel, I look at real legal cases that demonstrate how federal protections under the law are applied in court. These cases can help you by providing insight about how the same protections might apply to you if your circumstances fall under the same laws. Today, I've got a fascinating case for you, the story of Lorene Schaefer versus GE, which demonstrates the hidden dangers of forced performance ranking and why some companies still use it. And stick around until the end, where I will connect this case to a bigger workplace issue that I covered in my video, The Hidden Truth About Performance Reviews and Job Security, because this happens a lot more than you think. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult a qualified attorney or HR professional for specific guidance tailored to your needs. Don't forget to like and subscribe. Jack Welch is the former CEO of General Electric, and he implemented a controversial performance evaluation system that was known as rank and yank. Today, it is widely known as forced ranking. But back at GE, when Jack was the CEO, they called it rank and yank. And this approach was part of Jack's management philosophy. It played a really key role in GE's transformation because prior to Jack taking over, the company was not doing very well at all. Jack was the CEO from 1981 to 2001. And during that time, this forced performance evaluation system worked in a way that forced employees to be stack ranked into three categories. The first one was your top 20% of your entire workforce. These people were considered A players. They were high performers who were rewarded with promotions, bonuses, and leadership opportunities. Then you had your middle of the road employees. They were considered B employees. They were competent, people who were encouraged to improve, but they were not considered stars yet. And then you had your bottom 10%, your C players. This was the lowest possible ranking that an employee could receive. And these are the employees who were often let go following the end of a performance review period. During the performance review annual process, employees were compared to their peers instead of being assessed individually against either their own individual metrics like goals or performance metrics that they needed to hit. Now, the reasoning behind this was Jack believed in continuous improvement, and this initiative required eliminating weak links. Continuous improvement is looking at what you're doing well and trying to get it to be even better, and then leaving what you're not doing well behind and focusing on what's really the strongest part of of your group, of your employee population. So to drive a high performance culture, GE routinely terminated the bottom half of its workforce each year. Now, GE became one of the most valuable companies in the world under Jack's leadership. They went from a market value of $14 billion dollars to $410 billion dollars. And this system fostered a very competitive environment, pushing employees to constantly improve. GE played a significant role in shaping the careers of many professionals, but not all experiences were positive, and this became evident in the case of Lorene Schaefer. Lauren was hired in 1994 as in-house counsel for one of GE's businesses, and from 94 through 97, she was business counsel in the litigation group at GE's aircraft engines business. She worked on a variety of matters, including commercial, contractual disputes, intellectual property disputes and employment disputes. Then in December of 97, she was promoted to Business Senior Counsel of Employment and Labor Relations in GE's medical systems business. And in that role, she provided day to day labor and employment counsel, as well as advice to the medical systems managerial team. In January of 99, she took on the additional responsibilities of handling the medical systems businesses' commercial disputes and litigation. Then in June of that year, she accepted a position as Employment and Labor Relations Business Counsel for GE's Power Systems business. And in December 2001, she was named Business Senior Counsel for that business. In May, she was named Business General Counsel of GE's transportation business, and this was the position that reported directly to the CEO of the transportation business and provided legal counsel and business advice to CEO and business leaders. This lady was a powerhouse, and I wanted to take a moment to share her history, her accomplishments within GE, because I think it says a lot about who is pursuing litigation when a person has a stellar record and stellar promotional opportunities. If you know anything about corporate America, not everything appears as it seems. And there are times when someone who is highly regarded and successful can suddenly go on a downward spiral. And a lot of times, people, especially outside of HR, wonder what happened. And there are a lot of assumptions that are made. But this lady was clearly, in a league of her own. In April of 2007, she was notified that GE decided to remove her from her role as general counsel. And then in May, the very next month, May of 2007, they placed her on administrative leave. Now, an interesting fact as I was reading through this case, one of the things that stood out to me was in all of her years of climbing the ranks of GE management, Ms. Schaefer was never promoted to the senior executive band compensation level. So, despite all of these positions that she had, even her last position where she reported directly to the CEO, she was never in an executive level of compensation pay band. So, and this was despite the fact that many male employees who previously held her position had been promoted to that level. After Schaefer was terminated, she filed a lawsuit alleging that GE's forced ranking evaluation process led to systematic discrimination against women. She attempted to escalate this into a class action lawsuit because she wanted to expose flaws in GE's evaluation process. She alleged that during every performance review period, women were disproportionately placed in the bottom rankings and denied promotions. And one observation I had as I was reviewing this case is how odd it is that the woman who was promoted so frequently to one of the highest positions in the organization was alleging discrimination against women. I think sometimes in corporate America, they give one token a benefit in order to dispel any rumors or possibly any truths to discrimination that is happening. But the lawsuit sought class action status by arguing that the performance review process created systemic gender discrimination. Given her position, Schaefer would have had firsthand knowledge of instances where women consistently received lower ratings than men and how this affected them in terms of a woman's performance, how it was viewed, a woman's opportunity for promotion, for advancement within GE. Her lawsuit would have brought all of this information to light publicly. The case was eventually settled, and the terms of the settlement are not public. However, it's safe to assume that GE identified flaws in its system because its forced ranking process was eliminated in 2015 and replaced with a more flexible, continuous feedback approach. Schaefer's lawsuit sought to challenge systemic biases within GE's evaluation process. And she did this by revealing just how something, a policy, could appear to be fair, could also be a disadvantage to women. And this case highlights a much broader issue at work for many of us in terms of policies that can appear fair on the surface, but when you put them in practice, they reinforce existing inequalities. We're talking about performance review systems today, but think about promotional criteria or pay, how it's determined, hiring practices, any policy that creates a hidden barrier that limits opportunity for certain groups while maintaining the illusion of fairness creates a bias. And disparate impact occurs when a policy appears to be fair, but it's disproportionately affecting a protected group. And in this case today, we're talking about women, but the same principles can be applied to minorities, older workers, or even those with disabilities, meaning if discrimination isn't explicit in a policy or a practice. It doesn't mean that it's not that discrimination is not happening. Every organization, through its HR departments, its legal resources, should consistently monitor policies to ensure that this type of discrimination is not happening. The ranking process at GE tended to favor aggressive, self promoting behaviors, which studies show men are more likely to exhibit in corporate environments. Also, women who took maternity leave or had caregiving responsibilities were rated as less committed, and that hurt their ranking. So, you can see from this example, even if a system or a policy doesn't explicitly say we are discriminating against women, the way it is applied can lead to a gender disparity in terminations and promotions. And that's exactly what happened at GE. This case really shows how subjective reviews and ranking systems can be used to target certain employees without explicitly violating discrimination laws. Now, despite widespread criticism, forced ranking systems are still practiced today by some organizations. General Motors, IBM, and Amazon all use some type of forced ranking analysis in their annual review process. Performance reviews can be tricky, so it's just important in general to be careful about what they really mean, regardless of how they're used. Even a good review isn't a guarantee of job security. In some cases, it can be a setup. If you want to learn more about how this happens, check out my video, Fired After a Good Review. If you have concerns about how policies are being applied to you and others in the workplace, there are things that you can do to protect yourself. The first, you want to look for patterns and outcomes towards women, minorities, disabled workers, older workers. You want to look for patterns that show that employees in those groups consistently receive lower ratings. And then you want to document what your findings are and consider speaking with HR about them or even legal counsel. You want to be cautious about performance reviews being used to remove employees rather than genuine conversations to evaluate performance. You want to also challenge any unfair reviews through your HR department. Consider talking with your EEOC by filing a complaint or speaking with outside counsel. The American Bar Association is an excellent resource to connect workers with advocacy groups and other lawyers who may be willing to look at your case without a fee associated with it, just to give you some insight on the patterns that you have identified. Have you ever received a performance review that felt unfair? Share your experience in the comments. Thanks for watching today's video, and I'll see you next time.